If you've spent any amount of time on the internet, then you've no doubt seen countless videos where someone engages in degenerate behavior and tries to brush it off by saying something along the lines of, "It's just a prank, bro." And historically speaking, to the surprise of nobody, the "it's just a prank, bro" defense doesn't really hold up that well in court. But normally that's in the context of criminal law, so what about civil law, specifically contracts? What happens if one party is serious about an offer, but the other party only made or accepted that offer as a joke? As always, due to a wide variety of circumstances, the answer is always going to be, it depends. But a party can absolutely sue for a variety of reasons, including but not limited to specific performance of a contract, promissory estoppel, breach of contract, or even fraud. And while yes, there are countless times where the subjective state of mind matters a lot with the formation of a contract, this video is mostly going to be focusing on objective contract theory, or the standard of if a reasonable, unbiased third-party observer would have believed the offer to be legitimate based on the totality of the circumstances. So let's take a look at a few cases throughout United States history where a party tried to get out of a contract or offer with the defense in the spirit of "it's just a prank, bro." And one of the most important cases on the concept of objective contracts is no doubt Lucy versus Zemmer in 1954. Mr. Lucy had made numerous offers to purchase Mr. Zemmer's farm over the years, and at one point they almost agreed to a sale for $20,000, but that deal fell through. Then one night, Mr. Lucy entered the restaurant owned by Mr. Zemmer, and after a bit of banter, they ultimately agreed to sell for $50,000, and signed the back of a receipt with the following message written out. "We hereby agree to sell W. Old Lucy the Ferguson farm, complete for $50,000, title satisfactory to buyer." But later on, when Mr. Lucy informed Mr. Zemmer that he had the $50,000 in cash and was ready to close the deal, Mr. Zemmer replied that he never actually intended to sell the farm to Lucy, and that it was all just a joke. Lucy sued, and upon reaching the Supreme Court, it was ultimately determined that the contract was in fact legally binding based on a number of circumstances, and that specific performance should be ordered. Between the history of the two parties, the revision of the contract to enable both Mr. and Mrs. Zemmer to sign the receipt, the attempt to bind the offer with $5, signaling a serious intent, as well as the lack of any attempt to stop Mr. Lucy from leaving with the receipt, ultimately created what is commonly referred to as an objective manifestation of assent, which is the fancy way of saying, if the reasonable and unbiased observer would have believed the offer to be objectively true, and the hidden intentions of the parties don't necessarily matter. And the objective manifestation test has been applied countless times throughout courtroom history, with a simpler example being Lubert versus Simmons. Ms. Simmons signed a set of promissory notes agreeing to repay a loan with interest to Mr. Lubert, who she and her two daughters were living with. Ms. Simmons moved out and then refused to pay, stating that she only signed the notes as a joke, which was not deemed a legally valid excuse. But while Lucy versus Zemmer may be one of the most important cases on this concept, it's not the oldest case I could find in the United States where the objective terms of the contract mattered. We can go even further back to 1907 with Emery versus Hagerty McKittrick Dry Goods Company. Emery's contract was about to expire, so he met with the company's president and said he'd be forced to quit if his contract was not renewed. The president replied with, "Go ahead, you're all right. Get your men out and don't let that worry you." The plaintiff thought that that meant his contract was renewed, but he was laid off several months later. Initially, the courts found that this was not a valid contract because the president never had any intention to renew the contract, and therefore there was no mutual assent. However, upon appeal, this decision was reversed, establishing the significance of the outward appearance of the contract. But what happens if an oddly specific set of circumstances makes the offer seem reasonable to one person, but it's an obvious joke to everybody else? Well, as always, it depends. In Barnes versus Treese, Warren Treese was the vice president of a punchboard distributor. A punchboard being an older type of gambling or lottery device which you would rarely see nowadays. On July 24, 1973, while testifying before the Washington State Gambling Commission, Mr. Treese jokingly stated that he would pay $100,000 to anybody who could prove that any of the Vendowin's punchboard devices were crooked, aka rigged or unfair, and everybody laughed at the obvious joke, but Mr. Treese continued with the jokes for a little bit, even after the laughter subsided. Meanwhile, Mr. Barnes was not present during the initial testimony, but he heard a part of it the next day on the news. The part where he made the joke, but without the laughter, causing him to believe that it was a serious offer. And being a prior customer of Vendowin, he did possess two crooked punchboards. So he phoned Mr. Treese and asked if the offer was legitimate, where Mr. Treese, who really loved the running gag, perhaps a bit too much, jokingly told Barnes that the prize money was in escrow and to bring the punchboards down to the headquarters. Barnes obliged and then was denied the prize by everyone else in the building who knew it was an obvious joke. Barnes then sued both Treese and Vendowin, and both the trial court and the Court of Appeals held in favor of Mr. Barnes. And it was explained that although the original statement from Mr. Treese drew laughter and made it an obvious joke, the subsequent statement's conduct and circumstances showed an intent to lead any hearer to believe that the statements were made seriously. And next up, let's talk about the all-American classic, Leonard vs. PepsiCo. Back in 1996, Pepsi ran the marketing campaign, Drink Pepsi, Get Stuff, to which points from bottle caps could be used to purchase prizes from a catalog. They even ran a commercial featuring several of the prizes, and at the end of the commercial, it displays a kid descending in a military AV-8 Harrier II aircraft, with an advertised prize of 7 million points. But Mr. Leonard did not think that this was a joke, and while he didn't find the prize in the official catalog, he did read the rules of the contest and discovered that he could purchase points at a rate of 1 point for 10 cents, and that he only needed 15-point labels minimum in order to place an order. The then 21-year-old Mr. Leonard successfully convinced 5 investors to lend him $700,000 to purchase the points. Mr. Leonard then sent a check for just over $700,000, the shipping and handling, and the 15 minimum labels. The offer was of course refused by Pepsi, who referred to the promotion of the aircraft as fanciful and that it was just intended to create a humorous and entertaining advertisement. Mr. Leonard then filed a lawsuit against PepsiCo, which garnered quite a bit of media attention at the time. So, did Mr. Leonard get his aircraft since he clearly met the prize requirements? No. A summary judgment declared that no reasonable observer would have ever believed the offer to be legitimate, citing multiple humorous key points, such as how it was completely unreasonable to believe that one could purchase a $37 million military aircraft for only $700,000, and that the alternative of drinking roughly 190 Pepsis a day for the next 100 years in order to accumulate the 7 million points was also unreasonable. Afterwards, Pepsi altered the commercial, changing the price of the aircraft from 7 million points to 700 million points and adding a "just kidding" disclaimer. And while Mr. Leonard never won his aircraft, he did get a 4-episode docuseries on Netflix titled Pepsi Where's My Jet? So at the very least, on the it depends spectrum of the enforceability of contracts, there are at least a few cutoff points. So now let's take a look at some of those almost moments. In Newman vs. Schiff, Irwin Schiff was a tax protester who had written several books on the topic, and strongly preached that citizens were not legally required to pay taxes, despite he himself having previously served time for not filing tax returns or paying them. On February 7, 1983, Mr. Schiff appeared on CBS News Night Watch, and shortly after being reminded of his jail time and fine, he stated, "If anybody calls this show, I have the code, and cites any section of this code that says an individual is required to file a tax return, I will pay them $100,000. Mr. Newman saw a rebroadcast of Schiff's offer the next day on the CBS Morning News, and then promptly called the television station and cited the requested code requiring individuals to file a tax return, and demanded the reward. Schiff refused to pay, and Newman sued for breach of contract. So did Newman win the money? Almost, but no. It was determined that the offer was indeed legitimate. However, it was also determined that the offer was only valid during that initial broadcast, and that subsequent rebroadcasts would not indefinitely extend the deadlines. So if Newman saw the initial airing and called while it was live, then Schiff would have most likely been on the hook to actually pay the $100,000. Another case involving the determination of if an offer is a contract is Harris vs. Time Incorporated. And if I butcher the pronunciation of the name here, I do apologize. 3-year-old Joshua Niesda received what he, or perhaps his mother, thought was a legitimate offer in the mail from Time. The front of the envelope contained 2 see-through windows, partially revealing the message. One window showed Joshua's name and address, and the other read the following: Joshua A. Niesda, I'll give you this versatile new calculator watch free, just for opening this envelope before February 15th, 1985, with a picture of the calculator watch. Joshua's mother opened the envelope, and then it revealed the additional words, "and mailing this certificate today." The certificate itself clearly requiring that Joshua purchase a subscription to Fortune magazine in order to receive the calculator watch. Joshua's father, Mark Harris, just so happened to be an attorney. So if you thought that this would perhaps be a small claims court case, well then you'd be very wrong. Instead, Mr. Harris launched a $15 million lawsuit in the San Francisco Superior Court alleging breach of contract, and requesting that all recipients of the mailer either be entitled to the promised item or have the opportunity to rescind their subscriptions. Needless to say, this strategy did not work out, and the maxim of "the law disregards trifles" was held, because more often than not, an advertisement is considered an invitation to offer rather than an actual contract offer itself. But one important detail in this case was that to some extent, the offer was actually considered to be accepted, but he never actually notified Time of the acceptance of the offer. Next up, let's talk about joke prizes and some lawsuits that were filed as a result, but for some reason or another, never made its way through the courts. FCC regulations prohibit radio broadcasts from promoting false, misleading, or deceptive descriptions of contests. Broadcasters are required to clearly explain the extent, nature, and value of the prizes offered. Furthermore, many other states have their own additional strict sets of guidelines. So in other words, if you offer the keys to a brand new car as a prize over the radio, a car better be included with those keys, or you'll be in trouble. And the FCC has in fact fined radio stations over the years for fraudulent representations of prizes. And the year 2005 brought us two similar radio prize-themed lawsuits. In late March 2005, KBDS Play 103.9 in Bakersfield, California, announced that whoever guessed the correct mileage accumulated that week by the station's two Hummer H2s would win a Hummer described as having 22-inch rims on April 1st. Shannon Castillo was one of the two listeners who correctly guessed 103.9 miles. Castillo then hired a babysitter to stay with her two kids so that she could be at the radio station at 6 a.m. on April 1st to pick up her prize, which ended up being a toy Hummer instead, causing her to file a lawsuit on June 21, 2005. Meanwhile, on May 25, 2005, DJ Slick of Hot 102 WLTO-FM announced that the station would be giving $100,000 to the 10th caller, and explicitly stated that the winner would become $100,000 richer, no joke. Marisha Gill was declared to be the winner, but instead of receiving $100,000 in cash, she received a $100,000 candy bar, and then filed a lawsuit on June 22, 2005, just one day after the Hummer lawsuit. Now, in both of these cases, the lawsuits were eventually dropped. Which brings us to our next radio station joke. On November 29, 2000, Ben Stone of 93.5 KORB radio station in Iowa offered on-air $150,000 over the course of 5 years to anybody who got the radio station logo tattooed on their foreheads. David Winkleman and his stepson Richard Goddard allegedly called the radio station and were told that the promise was legitimate before they met with officials at the radio station, visited a local tattoo parlor, and then an individual who stated that they were with KORB paid for the men's tattoos. Employees of the radio station then allegedly took pictures of the tattoos and placed them on their website, but never paid the men, claiming that it was a joke. It would appear as if Mr. Goddard voluntarily dismissed his lawsuit, while Winkleman's case was dismissed by a judge after failing to appear for a deposition and then failing to respond to a final notice. And a mugshot in 2010 revealed that Mr. Winkleman still had the tattoo. Now, for this particular story, I really want to point out that many news outlets posted contradictory statements on what happened, and some of the locals have even claimed that the details and allegations made by the pair in the lawsuit weren't entirely true. However, for the sake of sparking discussion, if we do take everything and the allegations at face value, looking at a paper by Keith Rowley, it seems as if it would have been easier to argue consideration or performance in this case as opposed to the other two radio lawsuits, but promissory estoppel may only come into play for the first year, since it seems as if multi-year contracts in Iowa do need to be in writing. And our final joke prize is Berry vs. Gulf Coast Wings LLC, aka Hooters. As a part of one elaborate April Fool's Day joke in 2001, Jody Berry was informed by her manager Jared Blair that whoever sold the most beer throughout the month would be entered into a contest to win a new Toyota. Throughout the month, Mr. Blair made remarks such as how he did not know whether the winner would receive a Toyota car, truck, or van, and that the winner would still be responsible for the tax. After the month, Miss Berry was informed that she had won. She was blindfolded and led to a parking lot, but instead of winning a Toyota, she won a Toy Yoda. Needless to say, she was not impressed, and she sued. At first, Hooters tried to get the case dismissed, stating that it was an obvious joke and that her employment contract said that she had to go through arbitration. But after it was determined that the case could in fact go to trial, an undisclosed settlement was reached shortly after. So while we don't know how much Miss Berry was awarded, her attorney, David Knoll, stated that she could go to the dealership and pick out whatever type of Toyota she wants. And because every time this story is brought up, people in the comments like to say that the toy is probably worth more than the car now, I decided to devote an entire 20 seconds of my life researching the answer to determine that no, it is not. Anyways, for those of you not familiar with law, a settlement is not an admission of guilt, and this can't be cited as precedence because there was no official ruling from a judge. So the big unanswered question here is if Miss Berry would have met the elements of consideration or performance, because after all, selling beer was already a part of her job description. So is working a little harder consideration or performance when you're already expected to work hard in the first place? So I found 3 semi-relevant cases, the first one also involving a car. In Mears versus Nationwide Mutual Insurance Company, Nationwide informed all of its claims representatives that whoever submitted the winning theme for their contest could win a pair of his and hers Mercedes. In October 1993, a member of the committee informed Mr. Mears that he had won. and on several occasions confirmed that he would receive the Mercedes, before finally being informed that it was just a joke in January 1994. Mears sued, and Nationwide argued that while the contest itself was legitimate, there was no contract ever signed, so they did not have to award the prize. And despite the jury's verdict being in Mears' favor, the district court voided the verdict and granted judgment as a matter of law for Nationwide. Until the Eighth Circuit Court reversed this decision, and Mears was awarded $60,000 in damages. The second relevant case is going to be Leone versus Precision Plumbing and Heating of Southern Arizona Incorporated. Precision promised Leone a bonus of 1/2 the difference between the estimated and actual cost of a construction project. After completing the project and saving $35,578.56, Precision refused to pay the promised bonus. Leone sued, and Precision argued that there was a lack of consideration because Leone merely did the job that he was required to do in the first place, which was to oversee the project at or under budget. However, Leone won both the case and the appeal for two primary reasons. The first one being that the bonus offer enticed Leone to maximize his crew's efficiency and work above standards, meaning that working harder can be consideration. And second, it was determined that because Leone was an at-will employee who could quit at any time, his continued employment with Precision was consideration supporting the bonus. And the final relevant case is going to be Gottlieb versus Tropicana Hotel and Casino. On July 24, 1999, Pennsylvania residents Rena and Sheldon Gottlieb took a vacation to Atlantic City, New Jersey. The couple visited the Tropicana Casino, where Rena Gottlieb completed the free sign-up to become a member of the casino's Diamond Club. This entitled her to one free spin on the Funhouse $1 Million Wheel promotion every day, with the grand prize being, of course, $1 million. After waiting in line for 5 minutes, Lena scanned her card to activate the wheel, and it landed on the $1 million prize. But then an employee quickly used another card to reactivate the wheel and pretended that the jackpot never happened. The case proceeded to trial, where eyewitnesses testified that the wheel did in fact land on the $1 million prize, and then Tropicana's story changed from "it never happened" to "there was no contract, so we don't actually have to pay." But a summary judgment determined that the combined acts of traveling, signing up, waiting 5 minutes in line, and even the mere act of spinning the wheel, which generates entertainment value to the benefit of the casino, all ultimately led to consideration being met. So while the answer is always going to be it depends, turns out that sometimes the minimum requirements can be much less than I thought they would be. And now let's talk about a different kind of contract. Marriage. So what happens if you get married as a complete joke? Well, it depends. In McClurg vs. Terry, the plaintiff one night challenged the defendant to be married to her on the spot, and she jokingly accepted the challenge. A friend with them just so happened to be a justice of the peace and performed the ceremony. Both parties knew it was a joke, and everybody in attendance also knew it was a joke, and they never acted as husband or wife before or after the ceremony. So because everybody clearly knew it was a joke, and those intentions were clear, the chancellor granted the annulment. But then in Gervin vs. Griffin, both parties agreed to get married so that the overworked Mr. Gervin could finally take a vacation. So while they knew that it wasn't a serious marriage, the reverend and the members in attendance did not know that. So because of that, the marriage was legally valid. Moving on for now, let's talk about the topic of gambling yet again. Let's say you and your buddies or coworkers agree to occasionally buy tickets for a lottery pool, and agree to share those winnings equally if one of you ever wins the jackpot. But then, one of you actually wins and decides they don't feel like sharing anymore. This has actually happened multiple times, such as in November 2009, when Americo Lopez stumbled upon a winning Mega Millions ticket after several years of pooling in money to buy them with his 5 friends. He discreetly cashed the ticket in by himself and then left his job, telling his coworkers that he needed foot surgery. His coworkers eventually caught on and then filed suit against him in 2010. And then in March 2012, a jury ordered the lottery winner to share his jackpot with his 5, now ex-colleagues. But there are many circumstances in which these types of agreements are not legally enforceable. And before I wrap up, I got one final honorable mention, the tale of Bernice Wyszynski. In 1965, a car dealership in Connecticut advertised a Pontiac sedan for 1,395 bananas. Bananas being a slang for dollars, but they did not include the dollar sign. Given that $1 could buy several bananas, she went to the supermarket and then showed up at the dealership with 25 bananas as a down payment, only to be turned away. Bernice then filed a false advertising charge with the State Consumer Protection Commissioner, and while one version of the story says the commissioner agreed with her, while another one says that the dealership gave in due to bad publicity, ultimately, Bernice did in fact get the car for 1,395 bananas, and the story even made it into her obituary. So when is a joke offer a legally binding contract? It depends. But if you enjoyed these stories, then I have some great news for you. I found so many examples of this that there will inevitably be a second video. And in episode 2, we'll even be looking at tales from outside the United States. But that's all I got for now. Have a wonderful day.